Good morning. I am Judge Leslie Kim Smith. We are now live streaming on YouTube and on the record. Calling case number 250000659NO in the matter of Lucius Fowler versus AHL Investments LLC et al. Counsel, will you place your appearances on the record starting plaintiff's counsel?
Good morning, Your Honor. Mark Service on behalf of Plaintiff Lucius Fowler.
Thank you.
Good morning, Your Honor. Azam Elder appearing on behalf of the defendant, Fort Station LLC.
All right. The court has scheduled this remote hearing on defendant 4407 Fort Station LLC's motion for summary disposition. I've had an opportunity to view the pleadings, and Mr. Elder, if you're ready to proceed, you may begin.
Thank you, Your Honor. Your Honor, obviously the court's experienced and understands that before filing a lawsuit, an attorney and the plaintiff must do some basic due diligence. When I looked at the register of actions in this case, a lawsuit was filed, I believe, in 24. My client wasn't named. There was an amendment. There's a first amendment.
I'm sorry, I apologize for interrupting you, but this case was filed on January the 15th, 2025. Was there a different case?
I think that was the first amendment, I believe.
No, it was the first complaint filed.
Okay, then there was something, all right, maybe I'm confusing it, but there was two amendments filed.
Yes.
So I guess my point is that there was the plaintiff didn't even seek leave of the court to do that. But my client was named this year. That's my understanding. My client obviously sold the property 18 months before the alleged fall. And then my client obviously is uninsured, Your Honor, and doesn't own the property. So, I got involved. I reached out to plaintiff's counsel, provided them with all the proofs, warranty deed, closing statements, an affidavit. We did have discussions. The plaintiff's counsel said, "Hey, I'll dismiss it without prejudice." I said it's not good enough. Obviously, nobody likes to get sued when they shouldn't be in a case. In this case, we have to file a motion, and basically it's pursuant to C8 and C10. C8 is pretty straightforward. They didn't allege any hidden defect. Therefore, under C8, the case should be dismissed. Under C10, they allege that my client was the owner, operator, and possessor of the land. I've provided a warranty deed, a closing statement, an affidavit, and I also provided the plaintiff's counsel with the names of the LLCs that purchased the property. I think AHL were the sellers that my clients bought the property from, and I think they owned the property maybe 7-8 years ago. So they shouldn't even be in the case. So based on the facts presented in the briefs, Your Honor, I don't believe that the plaintiff should be allowed to sort of use a slingshot approach and pull people into a case where they have no business being in a case. They've known about our position now for several months, so they had a lot of time to figure out what they want to do. They just amended their second complaint, again, without seeking leave from the court, where they did add the buyers of the property, the folks that bought it from my clients, and I believe they leased it to a company called like Quickmart, and they did amend their second complaint to include them. So I think it's only appropriate to dismiss the case against my client with prejudice, because there's really no justification to keep him in, and they've had ample time to say that they haven't had time to do discovery. That's just not how you do business. I mean, you need to know who you're suing before you file a lawsuit. And in this case, they've had ample time to pull title, to hire a title expert. And I think we've already helped them by providing them with, the relevant information that we know of. When my client sold the property back in, I believe, 2022. So I would ask the court to dismiss the case. There's no question of fact whatsoever. They provided no evidence to refute the warranty deed, the affidavit, the closing statement. And it's just appropriate under C8 and C10 to just dismiss my client with prejudice. And I would request that the court give us that relief. Thank you, Your Honor.
Okay, and in response?
My response to that is, Your Honor, there has been no discovery done. No one's filed an answer to the complaint. The original company that we had filed against AHL Investments provided me with a 37-page document of the sale to 4407 Fort Station LLC. It was dated on the same day that 4407 Fort Street LLC is alleging that they sold it to this other entity. They sold it on a land contract. They did not provide the land contract or any of the language of that contract, which would determine, who had possession, who had control of this property. All they've provided is 2 pages of the warranty deed, which omitted the land contract or that it was sold via land contract, and a self-serving affidavit from their alleged previous owner. So again, we haven't been able to conduct discovery. No depositions have been taken. No documents have been exchanged other than the 2 documents that defense counsel has provided to us. And we ask that, this motion be denied until discovery be conducted and we're given our due day in court.
All right. I'm not sure if it was, I think it was attached to your response, but I found a warranty deed that conveyed the same property, but it was from 4407 Fort LLC to 4407 Fort Station LLC, and that was executed on September the 19th, 2022. So are you aware of this 4407 Fort LLC?
Is that directed at me, Your Honor?
It is.
Yeah, so that's the entire chain from from Wayne County deeds, and that was back in 2016 when that conveyance, I believe, happened. And
no, it says September 19th, 2022.
Okay, I guess I
Okay.
didn't.
All right, thank you.
Yeah.
Mr. Elder, anything else?
I just said when you do transactional work, the land contract is never recorded. That's just what you know when you do transactional work. Either there's a warranty recorded or there's a sort of a memorandum of land contract, which acts as notice to the world. But in this case, that doesn't matter. He's provided a warranty deed that was recorded. He now knows the entities that bought it from my clients. That's why he amended the second complaint. So he's going to go after them. And again, I see no reason why not to grant my motion under C8 and C10. He's provided no good faith argument to keep us in and to keep my client bogged down spending money on a case like this.
Okay, well, I don't know how much money your client would have to spend because, one of the issues is this case was just filed with the court January the 15th, 2025. I did review the first amended complaint that was filed on March 31st, 2025, and that amended complaint added 4407 Fort Station LLC. Then there was a second amended complaint that was filed on June 17th, 2025, and that added defendants 4407 Fort Street LLC and defendant Quick Stop Mart Inc. One of the problems that I'm having is, as plaintiff's counsel has indicated, discovery has not even begun on this matter. Plaintiffs have included some other entities that are named as defendants. In this case, as I've indicated, I reviewed the warranty deed that conveyed the property from 4407 Fort Station LLC to 4407 Fort Street LLC. That document was dated September the 19th, 2022. But then there's also a warranty deed that conveyed the same property to 4407 Fort LLC to 4407 Fort Station LLC. Again, that was signed on September the 19th, 2022. So it's unclear to me in terms of the title history, it seems to be somewhat confusing. So in light of the fact that discovery has just begun, I'm going to deny defendant's motion for summary disposition under MCR 2.116C10, as the motion is premature. Discovery has not really started on this matter. With regards to the argument under MCL 2.116C8, the court finds that this, reviewing it under this court rule, there's sufficient allegations to support the claim of premise liability and ownership. So I'm going to deny defendant's motion for summary disposition. That denial is without prejudice, and at some point in time, I anticipate that plaintiff will either stipulate to dismiss your client, or there will be another motion for summary disposition filed.
Your Honor, just for the record,
Uh-huh.
the reason why the court may seem confused is that there was a simultaneous closing where my client bought out or paid off the previous sellers, and then he sold it on the same day. Again, I disagree with the court respectfully. I think that you can hire a title company, pay them $500, and they would have explained all that to the plaintiff's counsel. I just don't think it's fair for people to be bogged down in a lawsuit when they shouldn't be named, but it is what it is.
Well,
Thank you, Your
well,
Honor.
let me ask you this. It seems to me that plaintiff's counsel has offered to dismiss your client without prejudice. Is that something that's still on the table?
Can I give a brief rebuttal, Your Honor?
Go ahead.
I did contact the title company, and I provided them the documentation that was provided by the defendants. They could not verify the legitimacy of the documents that were provided by the defendant. They could verify the information that I provided as Exhibit 4, which is the transaction that he's talking about, which was from 4407, or from AHL Investments to his client, 4407 Fort Station. So I was able to verify that transaction, but I wasn't able to verify the subsequent transaction that he provided to us. So
Were the warranty deeds, were they recorded?
so
For
the
sure.
warrant, yes, Your Honor, the warranty deed was recorded with Wayne County.
Okay, all right. I'm still going to deny the motion without prejudice.
Okay, thank you, Your
All
Honor.
right, if
Your Honor, is the Mark, are you going to dismiss them without prejudice and proceed with the other defendants?
I have to do a little bit more discovery.
All right.
all right, if there's nothing
Thank you.
else, matters adjourned.